Hi everyone, this is Jennifer Mondino with the National Women's Law Center. We're going to give folks just a few more minutes to sign on, and then we will get started. Hi everyone, it's Jennifer Mondino with the Time's Up Legal Defense Fund and Legal Network for Gender Equity at the National Women's Law Center. Thank you all for joining us for the second part of our webinar series on trauma-informed legal advocacy. We are really grateful to our fantastic lineup of presenters that have agreed to share with us their expertise this afternoon. We're also really grateful to the National Employment Lawyers Association, NELA, for agreeing to co-host this webinar with us, and to the support of the National Women's Law Center for letting us bring this webinar to all of you today. Also, I wanted to make sure to say thank you to all of the attorneys in our Legal Network for Gender Equity for agreeing to be part of our network and volunteering your time to help the folks who are coming forward to us with their stories of abuse and harassment in the workplace, and for making the time to learn about trauma-informed legal advocacy on this webinar today. I know many of you joined us for part one of the webinar series last week and had really good feedback and questions for us about that too. We think it's incredibly important that people have a foundation in trauma-informed legal advocacy before working with survivors, and so we appreciate you all making time to learn about it by attending this webinar series. So I'll just really briefly tell you all who is going to be presenting, and then I'm going to try to leave most of the time to our presenters. So today we're going to be hearing first from Adriana Rodriguez. She is an attorney with the Texas Rio Grande Legal Aid based in Texas. They are also one of the organizations that have an outreach grant from the Time's Up Legal Defense Fund, which means that we have awarded them money to do outreach to give people more information about their rights and remedies as survivors of sexual abuse and harassment in the workplace. So we are really happy to be partnering with them for this webinar also. We're also going to be hearing from Farah Gold, who's a senior sex crimes counsel with the Civil Rights Division in the criminal section of the U.S. Department of Justice. She is probably the attorney who brings the most cases of prosecution against law enforcement officers for sexual assault in the country. So we're really excited to be able to have her talk to you all today. She's joined by Melissa Milan, who is a victim witness coordinator with her in the criminal section of the Civil Rights Division at the U.S. Department of Justice. And Melissa and Farah partner really often on these cases of prosecution of law enforcement sexual assault and misconduct. And she also brings a long history of working with victims of domestic violence and sexual assault in her work in the government and before she was with the Department of Justice also. Last but certainly not least, we will have Leslie Orloff, who these days is a professor at the American University Washington College of Law. She is the director of their National Immigrant Women's Advocacy Project and is someone who brings a long history of experience and expertise working with survivors of domestic violence and sexual assault, and in particular immigrant survivors of domestic violence and sexual assault. So we are thrilled that she will be able to join us and share some of that expertise today. So without further ado, I think I am going to now turn it over to Adriana.
Great. Good afternoon, everyone. My name is Adriana Rodriguez. Greetings from Texas. I joined you as part of a network in Texas of agencies that are supported and supportive of survivors of sexual assault. You will notice on this slide here that there's the trans and pride flag at the bottom of our title slide, and I encourage you to be intentional as you do outreach potentially in your communities or as you consult with folks who may identify as LGBTQ, that you are mindful of your verbal and nonverbal messaging. And we do that here at TRLA's LASA Project because we want to make sure for folks who are looking for these flags that they can see them and they know we are a safe space. And for folks who don't know, sometimes that prompts a really great conversation about how we provide accessible services to all involved. So on the next slide, you will see that if you are interested in referring a client to us, if you're working with someone in Texas or if you are an advocate in Texas, you can give them our 1-800 number, 1-800-991-5153. You are also welcome to refer a client to us if you're working with someone in Texas or you encounter someone in Texas by emailing lasareferral@trla.org. And if you'd like to learn more about the civil legal services we provide for survivors of sexual violence in Texas, check us out at legalaidforsurvivors.org. And of course, follow us on Facebook, Instagram, and Twitter. So moving on to the next slide. I'm going to start us off with a little background on trauma. Now, in our efforts to be trauma-informed and client-centered as advocates, as agencies, as law firms, it's important for us to understand a little bit about trauma generally. Now, we know based on trauma experts, including Peter Levine, that trauma is not the event itself, but instead our reaction to the event. And it really results in a loss of resiliency in our nervous system, thereby impacting how we interact with others and sort of how we experience daily life. On the next slide, you will see that trauma can result from a single event or a series of events. And while we may be accustomed to applying a reasonable person or objective standard, I encourage you to think about trauma in a very subjective way in the context of our clients who may have experienced sexual violence. We know that the traumatic sexual violence clients experience at work and sometimes at school and sometimes also at home can result in tremendous physical or emotional harm. And we know that it has lasting effects on how our brains as trauma survivors function. And what we are learning is that trauma really overwhelms our ability to cope, control ourselves, and connect with others. Consider also that we as trauma survivors and our clients as trauma survivors may not be able to choose our trauma response. And so a lot of times, even with the best of intentions, for example, in the courtroom or at mediation, you see a trauma response that you didn't anticipate and one that doesn't seem to match with your client's personality. And it may be very well that you are witnessing a trauma response. On the next slide, you will see that we know trauma comes from multiple sources. And a lot of us in life, a lot of us very well on this call and our clients, may have experienced multiple traumatic experiences. Clients who have experienced interpersonal violence, whether in an intimate partner setting or in their home setting growing up, has sometimes have trauma responses or trauma scars. Childhood trauma can stick with our clients independent and separate from the sexual violence they've experienced in the workplace. We know that childhood abuse and neglect has lasting impacts. So too do the collateral effects of substance use and food disorders. And of course, particularly if you are providing pro bono or low bono counsel to someone who is poor or who has experienced is experiencing poverty or homelessness, the multiple causes of trauma can be tremendously traumatic and can really have an impact on the client's ability to participate meaningfully in the case and of course in life generally. On the next slide, I'd like to talk very briefly about the overlap of violence in our communities. Now, all of you are signing up to help survivors of sexual violence, and those efforts are certainly appreciated. Understand that in your work to help survivors of violence, you may be encountering survivors of domestic violence and potentially survivors of trafficking. And very few survivors of trafficking very few of them will self-identify. But I'm hoping to give you some tools in the next 3 slides to understand when you're working with a client who's potentially experiencing violence at work or at home and may be in danger. And it may prompt you to refer them to a shelter or rape crisis center or to someone who can help them plan for their safety. On the next slide, you'll see the domestic violence spectrum. And this is something many of you may be familiar with. A lot of folks are familiar with the power and control wheel. But you will see as the spectrum escalates towards the right, a client who is in a violent relationship at home may disclose to you in passing or in an interview that they are being threatened with harm, that they're being punched or slapped. And it can escalate to sexual violence too, including forced penetration. If you are working with a client who discloses that someone has impeded their breath in any way, whether it's strangulation or choking, as our clients sometimes say, or any kind of suffocation or asphyxiation, understand you're talking to someone who's in a tremendous amount of danger and probably needs to consult with a domestic violence specialist. Most domestic violence shelters can offer safety planning by phone, and towards the end of the call, I will give you a hotline number you can give to clients who can safety plan with someone on the National Domestic Violence Hotline. And of course, in the most deadly, most high-risk situations, you're potentially working with a client who's being threatened with and hurt by a perpetrator who's using weapons. Similar to the domestic violence spectrum, on the sexual violence spectrum on our next slide, you will see that the sexual violence, both in the workplace, but also at school, in the non-intimate partner setting, can also escalate. And if clients are making these kinds of disclosures to you in your initial interview or throughout the course of your representation, listen carefully for whether you are working with a client who's experiencing violence. So we know that the sexual violence spectrum shows that violence can start off in the workplace as mere intimidation or sexual harassment, catcalls, unwanted comments, maybe even some gestures, but it can also escalate to coercion or exposure. So you have, of course, flashing, but also potentially supervisors or coworkers sending unwanted texts, pictures of genitalia, asking for pictures of a client's intimate parts. escalating all the way to molestation or unwanted touching, whether it's the accidental, supposedly accidental, butt pat or boob graze. And of course, it can escalate in the worst of circumstances to sexual violence, oral, vaginal, or anal penetration. You'll notice that I say the words, and I encourage you to do the same in your initial interview so you can confirm that you and the client are talking about the same thing. Sometimes we resort to euphemisms and we hope that we and the client are discussing the same kinds of acts, but it's worth being specific and using specific language. And thereafter, once you've confirmed that you and the client are talking about the same thing, I encourage you to match client vocabulary. On a case that we had involving sexual violence in the workplace where a client was anally penetrated by her supervisor, we confirmed initially that we were talking about anal penetration. And then afterwards, we used the client's preferred phrasing, from behind, as we continue through the through the interview. And I encourage you to do the same. And of course, in the worst of circumstances, sexual assault with a weapon, someone who's being sexually assaulted at work, and if you're working with someone on the field using tools that are part of their industry, it doesn't necessarily have to be a gun or a knife, but potentially anything that could be used as a weapon. If you're having a client make this kind of disclosure in an interview, you're going to want to make sure you're planning for their safety and that you're thinking through what they need to keep safe on a daily basis. On the next slide, you'll see the human trafficking spectrum, which includes essentially definitions of force, fraud, and coercion, but lining them up on escalating violence, you will see, not unlike the domestic violence spectrum, that the abuse can begin as emotional or economic and then can become more serious with actual or implied threats to harm. And what I mean by implied threats to harm is that sometimes you have supervisors who are armed or carrying weapons that are never actually used against an employee, but contribute to an environment of intimidation, contribute to the employee's sense that they must do what their supervisor or their handler or their boss says or else. Sometimes you may hear about diminished resistance or inadequate care, particularly if you're working with a survivor of violence who stays where they reside in the context of domestic workers or agricultural workers. And of course, in the most obvious context, physical or sexual force, and as was mentioned in the past two spectrums, any deadly use or use of a weapon. If you are reaching the far right of these spectrums with any clients, or as you see the violence escalate towards the far right, acknowledge that you are potentially working with someone who is in a tremendous amount of danger and ultimately needs some help in planning for their safety in order to continue to participate meaningfully in the case that you are assisting with. On the next slide, you'll see just a reminder to be trauma-informed and consider all the challenges our client has encountered in accessing our services, your services, and simply getting to a meeting with you. Outing yourself as a survivor of sexual violence, whether you identify as LGBTQ or not, can require a lot of courage. And so when someone is making these kinds of disclosures to you, they are signaling to you that they trust you. Consider also that our clients sometimes have to request time off of work to make meetings with us, and do your best to be kind and, of course, patient with clients as they struggle to potentially tell you what has happened to them in a cohesive manner. On the next slide, just here are some examples of common trauma triggers. As I mentioned earlier, we don't really know when we as trauma survivors and our clients as trauma survivors are going to be triggered, but some examples include anniversaries or life events, sounds, smells, colors, and objects. We know trauma is linked very much to the senses. Any kind of sensory overload, really. Any feelings of vulnerability or rejection, including, for example, when a mediation doesn't go well or opposing counsel is doing a pretty vicious cross-examination of the client. Anytime a client feels lonely or a sense of separation, any conflict or change, which is again something to be expected in a deposition, for example, or cross-examination, but really any sense of a lack of power or control can be a trigger. On the next slide, we have some examples of the common signs of trauma. So you are potentially working with someone who has either experienced trauma or is having a trauma response. If you see explosive anger, sometimes we as the helpers experience or are targets of anger, and it's really not personal. We just happen to be the ones that are being targeted. A fixation or over-analysis with getting in touch with you, or a particular detail or a particular disclosure that or admission they want the other side to make. Sometimes this manifests with clients calling you every hour on the hour. And then a shift to when you return their phone call, they actually never call you back, or they become kind of avoidant. Those are potentially trauma responses. If you're working with a client who during the course of your representation has a tremendous spike in their weight or a tremendous decrease in their weight, you're potentially dealing with someone who's developed a food disorder as a way to kind of control how are they feeling. Any kind of cutting, for example, is a potential sign of trauma. But also anyone who has an emotional lockdown during the course of a discussion with you, or tends to minimize the violence perpetrated against them. Clients disclose intrusive thoughts or nightmares. And of course, you may hear when clients describe the sexual violence they've experienced that they fought back, or that they ran, or they didn't tell anyone, or they engaged in promiscuous behavior after the sexual assault to regain a sense of control. Now, on the next slide, just a word on trauma and memory. Consider that our clients may not have conscious memory. As many of you may have heard when Olga Trujillo testified about explained her experience with disassociation. Sometimes clients don't really remember what has happened to them. They may have out-of-body recollections or out-of-body experiences during the traumatic event that they're describing. So chronological recollection can be very, very challenging. But what we've learned is that if you ask clients sensory questions, you can sometimes see an improvement in clients' capacity to remember, and that potentially improves also when clients are resting and getting sleep. In the context of drug-facilitated sexual violence, it's to be expected that clients may not remember huge chunks of time of the incident, but also consider that our clients may feel guilt about things that led up to their eventual sexual assault or the sexual violence they're experiencing at work, and they may choose to omit details if they feel either guilty or they feel that you will judge them. And so patience and telling the client that you believe them can go a really long way to gain client trust. On the next slide, just recognizing that memory impairment is a reality, whether you're talking about drug-induced sexual assault, whether you're talking about a client who is highly articulate or a client who is quite shy and reluctant to share. You know, traumatic memories are certainly processed differently, and you should, as a good attorney who's sitting with your client, expect contradictions. But do be honest with clients and identify and discuss inconsistencies between potentially the written statement they provided to their employer and the police report and what they are now telling you, and make an effort to understand why there are variations. It is important, like I mentioned, to reassure the victim that you believe them, but it's also good for you as the attorney to determine whether you might need an expert witness to explain these gaps in memory, or to explain why there are some issues or inconsistencies in the different times the client has discussed what has happened to them. On the next slide, just to sort of recap the impact of trauma, we know people who have experienced trauma, victims of violence or otherwise, are 4 times more likely to become alcoholics, develop a sexually transmitted disease, inject drugs. They are 3 times more likely to use antidepressant medication, be absent from work, which no doubt has an impact on their employment case potentially, 3 times more likely to have very serious job problems, and 3 times more likely to experience depression. Of course, they are also 15 times more likely to commit suicide. And towards the end of my portion of the presentation, I'm going to give you a number that you should keep handy for the National Suicide Prevention Hotline. And on the next slide, just again, an overview of the effects of domestic violence and sexual violence. Some of the clients you're working with may have a real breakdown in their sense of personal integrity and a very legitimate frustration with the criminal justice system, particularly in the context of sexual violence and delays in rape kits and all of the frustrations they may have and how they were interviewed by first responders and how they've been treated. So I encourage you also to become familiar with crime victims' rights in your state. And I'll remind you on the next slide, there is no such thing as a perfect victim. You are going to have clients who have skeletons, who have bad facts, and just be honest with clients about the potential impact. Be ready to potentially explain them through direct examination or kind of getting ahead of whatever may come up on cross, and always, always, always consider using an expert witness. On the next slide, I just have a couple of takeaways, and that's something that we try to promote with our LASA project and our attorneys at TRLA, and understand that our attorneys do a full spectrum of civil legal services. We don't just have employment lawyers. We have family law attorneys, immigration attorneys, education attorneys, and we encourage our attorneys, like I'm encouraging you today, to make an effort to understand the impact of trauma. Do your research, attend webinars like this and many others. Actually prepare to meet your clients. And I mean that not just in knowing the facts of the case, but emotionally as well. Make sure you are the best version of yourself for that first client meeting, or any client meeting for that matter. Also, I think it's worth recognizing the power and trust dynamics between you and the client. How might the client perceive you based on your gender, your race, your socioeconomic background, your level of education, and be mindful of how the client perceives you could impact how quickly they trust you. I would encourage you throughout your representation, not just at the beginning, be trauma informed in assessing ongoing safety and privacy concerns. Do your best to determine client goals at the beginning of your representation, and do your best to manage client expectations. The worst thing we can do as attorneys, particularly working with trauma survivors, is overpromise, right? Don't promise anything. If anything, explain the likelihood or based on your experience, but we can never really guarantee clients an outcome, and our clients are really, really vulnerable, and yet another disappointment could very well be the tipping point for their motivation to keep going on their case. And like I'm doing here today, I encourage you to educate others about trauma, including with the use of an expert witness, but also be mindful of your own trauma exposure. Set aside some time to check in and see how you are impacted by the facts of your case or by the disclosures your client has made, and kind of set up a plan to take care of yourself and have potentially a strategy for decompressing. On the next slide, a couple of just guiding principles. Be sure in the course of your representation that you respect survivor choices. It is ultimately the client's case, not ours. Recognize the risks of getting help or reporting, particularly with clients who are vulnerable and have ongoing privacy concerns. Calling the police may not be the best and first option for a client, because they lose a sense of their privacy there, and they may not be ready to talk about the violence perpetrated against them, either because it's embarrassing or overwhelming, but also because they may be somehow implicated, as is often the case with survivors of sex trafficking. I encourage you also to listen carefully for the survivor's unique needs beyond the scope of your representation, so that you can connect the clients you're working with, the survivors you're working with, to community resources. If the clients aren't well, they won't testify well. They can't be actively participating in the case with you. On the next slide, I've got just a reminder of things to ask clients about when I say listen for clients' holistic needs. I mean, most of you are going to be providing employment law services, and Leslie's going to talk us through some of the immigration remedies available to clients. But listen for some of these other issues as well. And I hope that you'll take this sheet, potentially print it out and stick it in your agenda or your portfolio or whatever, as a reminder to ask clients about the other things happening in their lives, and to know who you can refer them to in your community. And just sort of a recap on the next slide of best practices for client meetings. Careful to explain how much time you have and the goals for the meeting, and give clients an opportunity to add a few agenda items. Notice your nonverbal cues. Are your arms crossed? Do you seem disinterested? Are you on your phone? Ask about safety throughout the course of your representation. Ask sensory questions when clients are struggling to remember. Use specific language to confirm that you and the client are talking about the same things. Make an effort to be culturally responsive. I think clients can tell when you're trying to be kind and doing your best. And so don't worry about messing up. If anything, just demonstrate how earnest you are being in trying to be culturally responsive, whether it's a difference in heritage or nationality, or if it's a difference in sexual orientation, identity, or expression. As I mentioned earlier, match client vocabulary. ask about slang you don't understand, even if you speak Spanish and the client speaks Spanish. There are different issues sometimes with dialect. If you're working with a client who's much younger, no need to pretend to be hip. If you don't understand the lingo they are using, make sure you clarify. And do what you can to empower the client and promote resilience, because that's ultimately why all of you have agreed to do this work. The next slide, just to recap, I encourage folks to definitely confirm safe callback numbers at the beginning of your representation. Figure out if it's safe to mail documents to a client. Figure out if it's safe to email information to a client. We cannot assume when we're working with a survivor of violence that we can communicate with them like we would communicate with all clients. And just a couple of helpful hotlines as we wrap up this first portion. The National Sexual Assault Hotline is 1-800-656-HOPE. They have a crisis hotline, and they offer a lot of great resources, including referrals to service providers in your area. There's the National Domestic Violence Hotline, 1-800-799-SAFE. They can connect clients with a domestic violence shelter in their area. And this is a number everyone should have saved on their phone. The 1-800-273-TALK is the National Suicide Prevention Hotline. If you are interested in learning more about trauma, I've got 3 resources here for you. I always sit with my back to the wall: Waking the Tiger, Healing Trauma, and The Developing Mind on that next slide. And those are 3 excellent resources that I recommend. And a couple of websites for you if you want to go deep and you want to see how others talk about sexual violence. There's RAIN. There's the Victims' Rights Law Center, which has been doing this work as an agency for a long time. If you're working with survivors who are migrant farm workers, the Migrant Clinicians Network has a lot of great resources. The National Network to End Domestic Violence has a lot of good one-pagers you can share with your staff. And if you'd like to learn more about trauma and its impacts on the brain, check out Harvard Center on the Developing Child. I am definitely available by email if you have questions or if you'd like to follow up on any of these issues. Thanks very much for your attention for this first bit.
Thank you so much, Adriana. Now we are going to turn it over to Sarah Gold and Melissa Milan.
Hi, everyone. I just want to start, and we can go to the next slide. We're going to specifically talk about interviewing victims or survivors of sexual misconduct. And I just want to, as we're waiting for the next slide, I just want to let you know that I'm a career prosecutor, as Jennifer mentioned, and now prosecute law enforcement and sexual misconduct cases, but I used to prosecute state sex crimes, so I tend to use the word victim instead of client, and I also tend to use the word victim instead of survivor, but please know that it all means the same thing for our purposes. And similarly, I often use the pronoun she because the vast majority of victims are female, and I also tend to think in criminal prosecution terms instead of civil, yet the idea of eliciting a coherent account, and if we go to the next slide, what we're going to talk about applies the same whether we're developing a civil or criminal case. So in the next half hour or so, the points that we're going to hopefully get through is to how to elicit a coherent account from a victim of sexual misconduct. And then Melissa's going to talk a little bit more specifically about understanding trauma and how it may affect that account that you do want to get. And then I'll come back and talk a little bit about developing evidence to corroborate that account. And then also simultaneously a little bit about what you heard before when you hear about that right end of the spectrum, when you get into potentially criminal conduct, what constitutes a prosecutable crime, and what your potential avenues for that. So just initially, if we could go to the next slide, the initial meeting, the initial interview that you have with a client, or as I say, a victim, a lot of this is repetitive, so I don't want to go into what you heard before, but the interesting thing that all of you are facing is that hopefully you have somebody who is interested in talking to you and not necessarily resistant from the outset, because he or she did contact the Legal Defense Fund. And so what do you do in the very beginning to talk to somebody who's coming to see you for the first time? And as you heard before, gain or trust. How do you gain someone's trust? Discuss your own experience, help build confidence in yourself, and kind of get used to being the person who's going to talk the most in the beginning, because it's difficult for a victim to walk in and from the outset discuss with a stranger some of the most intimate aspects of his or her life. And again, just to reiterate, I guess it's good when presenters are saying the same thing. Don't make any promises, because we can never promise any outcome. What we can promise is that we'll answer all the questions throughout the process, that will be upfront and honest, and that will keep them informed. And I have found in the criminal context, certainly, if I can just let a victim know as the process goes on what to expect, that's a lot of what they want, and they feel a lot better going through it, as long as they feel informed and to some extent in control of the mess we can provide that. And again, you heard before that it's really up to the victim, or your client in this case, as to how far he or she is going to go, because really the process hinges on that victim coming forward. So you have to recognize that from the outset, that there's only so much we control as the attorneys. But before I go into more about getting that coherent account, I'm going to turn it over to Melissa to talk about the neurobiology of trauma.
Hi, everyone. This is Melissa. We can, well, to begin with, we'll go over the neurobiology of trauma. We'll quickly look at understanding trauma symptoms and being trauma-informed, and just hopefully we'll come together to understand that trauma is very real and significantly affects a victim's recall. So if we can move on to the next slide. I put this up here. This is a term that is used very often. It's a very current term. This is the actual definition from Science Daily. But to break it down just a little bit in terms of our understanding, the neurobiology is basically looking at the mind, the brain, and the behavior. So in your mind, your thoughts, your feelings, your emotions; in the brain, the parts of the brain and their function; and then, of course, how we might act. So neurobiology sort of attempts to explain human behavior for us. And the brain usually records the vast majority of the events, if you want to move on to the next slide, like the who, what, where, when, and why. But what it doesn't do is take into account when someone is experiencing a highly stressful or traumatic event. That's where we get the term neurobiology of trauma. So what's important here is to not overlook the manner in which trauma shapes memory. If we move on to the next slide, I put up a picture of the brain, and obviously there are a lot of pieces of the brain that are not highlighted in this picture. I did put a couple of the critical areas of the brain up there, and there are two that I want to focus on in particular. If we move to the next slide, the amygdala is super important when we talk about the experience, the trauma experience. So this is usually the place that helps us to process our emotions. I put up here, think survival, your instincts, your motivations. However, in a situation where you're experiencing something uncomfortable, something unpleasant, something very scary, traumatic, it sets off alarms when the body encounters that danger. And what happens next is that the adrenaline, the amygdala pushes out and just floods the body with adrenaline. That, in turn, if you would move on to the next slide, please, affects our hippocampus. The hippocampus, the most important job that it has is to store memories, especially long-term storage of memories. But when that adrenaline pushes through the body, the amygdala is now in alarm. It forces cortisol out of the brain to stop the pain and to survive. So if we move on to the next slide, what that means for you is, and especially if you're sitting down with someone and seeking to interview them, is that the hippocampus, which in a non-traumatic situation would have more than likely stored all of that information very coherently for that person, in a traumatic situation has that file cabinet is all mixed up. So some of the things you may see are a very angry person, somebody with very flat emotion or perhaps on edge. It does not at all mean that victim survivor is not listening or does not want to talk. It is trauma talking. They are distracted by their shock, their anxiety, flashbacks, concerns for their safety, etc. So one of the things we want to take a look at and keep in mind at all times is that these neurobiological changes do affect memory. And I think Adriana touched on this a little bit in her presentation, but just to keep in mind that sequence of events are very difficult for victims, survivors to be able to recall the events in. They can come out fragmented, sketchy, they can be all over the place. This, when you're interviewing someone, may make you feel like perhaps they are not telling the truth, or maybe even perhaps making things up as they go along. What's most critical here is that the traumatized person may experience intense emotion, but without clear memory of the event, or on the flip side, may remember everything in detail, but without emotion. So very important here, the accuracy of the memory is not impaired, it's recall that is the problem. Next slide, please. Actually, I'm sorry, the next slide, yeah. So just a couple of more slides. The impact of trauma, to keep in mind, stress hormones, cortisol and norepinephrine are the two neurochemical systems that are critical in stress response. That's where you get into the conversations about fight, flight, or freeze. You hear about victims during crime feeling like they could not literally move. That's what is affecting them. And to keep in mind that the brain is taking snapshots and sort of scattering them all over the place in their mind, making it very difficult for them to be able to tell you anything in a chronological order. I put this quote up here because I think it's pretty important. It says that she gave no details. She said she couldn't remember if it really happened, that there's no way she'd forget. This is often sort of a thought, particularly in law enforcement, that if something traumatic happens, someone would be able to remember every detail, and this is precisely the opposite, that often they know exactly what happened to them, but cannot describe where they were, cannot describe the day of the week or even the month, etc. So it has nothing to do with it not having happened. It's just that the trauma has scattered the memory. So keep in mind that when a victim is under attack, attention may be focused on details that cause them the most fear. So victims, it's almost as if time has stopped at the moment of trauma and they are primarily focused on their survival. And finally, on my last slide, please. Remembering to understand that it is difficult to recall specific events. You know, and the other thing too is to remember that it is highly possible that when you are talking about a traumatic event with someone, you are also uncovering major traumatic events in childhood, their past, and they are concealed beneath this current situation that you are trying to interview them about, and that is where, and I know Adriana talked about this a lot, but the triggers come into play.
So now if we go to the next slide, this is Sarah again. So I'm going to go over the considerations of the interview first. So now you've heard about trauma, you've considered all this, you know what to expect to the extent that you can. What do you have to do for the interview? What do you have to balance? And I believe that Adriana talked about the patience and time and being able to allot enough time, because it is going to be difficult because of the trauma and difficult because it is for anybody to come and talk about something sensitive to a virtual stranger. And so you really do have to allot enough time and be patient, because it's going to take a while for someone to be able to recount to you what they went through. But simultaneously, as an attorney who's looking to bring a potential case, be objective, be fact-driven, and develop a trust so that the victim tells you both the good facts, the facts that support her account, and the bad facts. Because as you heard earlier, no victim is perfect. As I said, I work in the world of law enforcement sexual misconduct. Those victims automatically have credibility issues baked in, and everybody comes to you with baggage, and you need to develop trust so that that person feels comfortable to tell you everything. And it's difficult, and it's going to take time in that first meeting and maybe subsequent meetings. But that is your goal, and it's a difficult goal to being objective, fact-driven, developing trust, getting the good and the bad, being detail-oriented, because you want to paint a clear picture for that ultimate judge or jury who's going to hear a case, but be sensitive to all of the things that Melissa just talked about and how trauma affects an account. So on the next slide, how do we accomplish that? What are the considerations for the interview? We talked a little bit about this before, but the physical setup of the interview. You know, I go all over the country when I handle my cases, and I meet with victims in all sorts of random places, whether it's their houses, libraries, whether it's at a restaurant or a diner, whatever makes them comfortable. You're likely going to meet with a victim in an office or in a conference room. And think about things like Do you have glass walls? Can people see in? Can people hear in? Can you close the door? You know, where are they most comfortable? Where does it seem the most private, but yet it gives the opportunity to that victim to leave, be near a bathroom, or not stay very long, and so he or she doesn't feel boxed in. But then there's also the dynamic of the interviewers. Consider gender, right? Does the victim feel comfortable if it's a woman talking to another woman, and so forth? And then there's also the physical position of you as the interviewer to the victim. If you're sitting across a desk, as Adriana mentioned, arms folded, that may not come across as inviting to tell the full truth, the good facts, and the bad facts. Consider this may be obvious sitting next to a victim rather than across from her. And then on the next slide, consider the balance of people in the room, right? Not just the gender, but how many paralegals you have in the room, how many advocates or assistants. Don't overwhelm or outnumber. And as I said, be very deliberate as to where you're all positioning. You don't want it to look like, you know, you're all sitting across from her and peppering him or her with questions. And if a victim is insistent that a certain person be present, a sister, a spouse, or something, or a friend, consider that as well, because is that person, that sister, that spouse, that friend, is that an initial outcry witness? And we'll talk about the significance of disclosure witnesses. They themselves, their accounts are evidence to support her accounts. And if that person is in the room, does it potentially taint the victim's initial accounts? Even though he or she wants that person in the room, will it affect his or her ability to be as forthcoming as you need it to be? Will that victim give you the bad facts as well as the good if that additional person is in the room? And then that additional person, even if it's someone who supports her, that person may become a witness just to the account itself, and there may be implications with attorney-client privilege. So consider all of that. Yes, you want the victim to be comfortable. Yes, you want her to be as forthcoming as possible, but the way in which to do that may be to limit the number of people in the room. And then if we can go to the next slide, just to reiterate, allowing for enough time, understanding that you may schedule it for 2 hours, it's probably going to take 3. So take breaks when he or she needs it. And that initial interview, that initial getting to know you, sometimes that getting to know you meeting is just so that she gets to know you versus the other way around. And it's a lot more time consuming, oftentimes in sexual misconduct, than just talking to people who have undergone, I hate to say regular crime, but in my experience, if I speak to a robbery victim, we can usually get through an account much more quickly than someone who has experienced sexual misconduct. And in the next slide, and again, to reiterate a point that Adriana made, your comfort is actually key, because you want that victim to relate to you and feel comfortable. And if you yourself are uncomfortable, she or he, that victim, is going to feel it and not feel like he or she can trust you and not feel like he or she can open up. So what does that mean? Be comfortable with the language she's using. If you don't understand, ask, right? Because honesty on both sides is paramount, and you don't want her to shut down. Just like you heard in the beginning with Adriana, use words like penis, vagina, and breast. I mean, get used to using it. If you think it's going to make you uncomfortable, practice saying it in the mirror. I know that sounds somewhat ridiculous. I think, you know, as adults, we should all be able to say it, but people can't. So use those words initially, and also use the words that she's comfortable with. However, there are certain slang terms where you can use, but if your victim is ultimately going to be deposed or ultimately be in a courtroom, you might want to work with her to get away from certain slang words that may be offensive to a potential jury. You want her to be comfortable, but at the same time, you want to also use the actual language the statutes require. So use those terms, but also use the actual terms that the statute has. And recognize your own limits. If you realize that it's too much for you, if you realize there's somebody better suited to conduct the interview, recognize your own limits and when you can be there, and there's nothing wrong with that. And on the next slide, to also continue with the considerations for the interview, language is everything, right? So yes, language in terms of English, Spanish, and the like, but actually the language that person is using when discussing it. If we're talking about sexual misconduct, sexual assault, we're not talking about consent. And this is kind of a point that I drive home all the time with my investigators, right? If somebody did something at gunpoint, they gave in or submitted. They didn't consent because they were at gunpoint. They didn't consent because he held her down. They didn't consent because she felt like she had no choice. She consented or gave in, and that's really important to recognize the distinction. Just like there's a distinction between flirting and laughing something off to get out of a situation, right? There's nothing wrong with that. And so if somebody says to you that, well, she flirted so that she could, you know, escape, or she laughed it off so as to diffuse the situation, That's fine. That doesn't mean she ultimately consented to the sex act. And then this may be obvious, but I've seen it written in reports. Somebody forced to make love. It's not making love if it's sexual assault or rape. And so that, again, is another example of choosing the right language. Again, going back to knowing how to use the words for people's genitals, or using the words vagina and penis versus private part. Which private part? Again, a pet peeve that I have when I work with sometimes FBI agents who use the word private part, and I have no idea what private part they are referring to, unless the victim actually uses that phrase and you ask what private part are you referring to. If she uses the word vagina, don't respond with private part. It looks, again, like you're uncomfortable and will make him or her uncomfortable. And so again, going to the next slide, again, the consideration for the interview. So being an objective investigator, because that's what you ultimately have to be. If you have a victim coming to you with a potential case, right, how do you figure out if she's telling the truth, if this really happened, and how to prove it, right? So there's this objective skepticism that we all have to come to meeting a potential victim. It doesn't mean we have to show it. And we don't have to accept everything at face value, but we don't want to convey that, right? So there's a difference between taking someone just at their word versus believing their accounts. We make decisions every day whether we believe people. And if you, in fact, do believe this client that comes into your office or wherever you meet her, tell her you believe her. If you don't, keep it to yourself, because it may be that takes you a little while to believe her. You don't want to let her know you don't believe her, and then it turns out that this actually happened. So again, there's a difference between I'm just going to take it but to value versus believing what she said. So how do you figure out whether to believe someone? Because that's ultimately what you want to do for a jury. You want to get as many details from the victim as you possibly can, right? And this is the significance of the interview. The more detailed the picture, the more credible she'll be to a jury. So how do you do that? You get very, very specific. Where were his hands? Where were your hands? And so forth. But not only that, you want to ask those tough questions. So like when Joanna was talking earlier about inconsistencies, you want to address those, whether it's the first meeting or the fifth, you make your decision based upon your relationship. But you want to figure out why there are inconsistencies. They may be very easily explained by all of the things Melissa talked about, by trauma. They may be very easily explained because a police report isn't consistent, because it's the police officer's version or his own recollection of what she said. But you want to ask those questions. And you can do it in a way without sounding accusatory, by saying, hey, listen, I know the answer to this, but a jury's going to want to know. For example, when he forced you to perform oral sex on him, why didn't you bite him? And you could just say it in a very non-confrontational way, just so you get the answer out there. It doesn't mean you're accusing. You can flat out say up front, I am not, please don't think I'm judging you. Please don't think I'm accusing you. I just need you to actually articulate these specific points for me so that I know, so I can paint the picture for the jury. Because the most important thing is to get your accounts out there. So how do you build a case? And I'm going to go to the next slide. I know I'm probably speaking extraordinarily fast. I'm trying to fit it all in. And I encourage all of you, at my email, my address, my phone number at the end of the slide, I encourage all of you to call or ask as many questions as you need to. But building a case. So you have this victim and she comes in and she gives you a credible account that you believe. Now this is really significant. The law doesn't require anything more than a credible account. That is all the law requires. There is not a jury instruction that is going to say you need physical evidence or you need independent corroboration. A credible account is all that the law requires. You don't need independent corroboration. However, it is always helpful to have more. So how do you build her credibility if there are no witnesses? Because as I often say, especially in sex crimes, these crimes don't happen in front of an audience. So if you don't have other people to say, yes, I saw it happen, how do you build the credibility of a victim's account? So looking at the next slide, this is where I'm really going to go fast through this, and I feel like you could have a long discussion about all of it, but you want to verify and corroborate details. How do you want to do it? Little things, like if she says it happened in a specific office at work, when you want to go look at that office and see, does the office layout or the office layout at the time that she says it happened, is that consistent with what she said? You know, is the layout the way it is? Are the doors the way she said it was? Were there people outside who may have overheard bits and pieces, who saw the boss go in, or whatever it may be? You want to just verify details surrounding the actual act, where you can't actually get another person to witness it because person who committed the offense, whether it be a crime or any sort of sexual misconduct, they're trying to get away with it, so they're not going to do it in front of witnesses. And I mentioned those early disclosures, those initial outcry witnesses, those people that inevitably the victim want in the room when he or she meets with you. The significance of that is that well before the victim comes to your office and says, this is what happens to me, it turns out that, you know, when this first started happening 4 years ago, she told her best friend, or she told her mother, well before she ever came to you, well before she ever filed a complaint or whatever it may be. Because the defense is often going to be that she is lying. Those accounts, those early disclosures that predate the complaint are admissible as prior consistent statements, admissible as substantive evidence to prove the crime. That is, that not only you have the victim's account, but you have all those people that she told that predated your involvement. Those come in to rebut a defense of fabrication, to rebut a defense that she's lying. So it goes to her account, but then you have all the other ones to show that she's been entirely consistent all along. So that's one really big way to build her credibility and corroborate her account. Another one is that oftentimes individuals who commit sexual misconduct, whether it is simple harassment leading all the way up to the violent rape that Adriana described, there are other victims. There's a pattern of behavior. They usually don't get caught on the first one. So I listed for you in the Federal Rules of Evidence for criminal cases, just to give you an idea, 413 allows in other instances of sexual assault to prove what a victim is saying. That means we can prove a victim's account by showing a pattern of behavior, by parading in all the other victims. So that is where you kind of have to put on your investigator hat and start looking at all the other say if your victim is a woman, all the other females she worked with and has access to this boss. Hey, even the men, find out comments that he may have made. And try to develop a pattern of behavior, whether it is just grooming, and that is another topic we could talk about, but you'll always find that your victim, your client, is not the only one. There is a pattern of behavior that extends probably well before, and if she waited to report, because there are delayed reports, most of them are, there have probably been more victims since. And so you kind of have to pound the pavement, go and talk to those victims, potential victims, that's when you have to go and try to meet people where it is most comfortable for them and talk to them about stuff that they probably don't want to talk about. If it's an employment conduct, see if you can get that employment file, find other complaints that have been made. And then also with assessing credibility, you have to look at history of drug and alcohol abuse and prior victimization. Both can either bolster or undercut credibility. I mean, there is a pattern, and you saw from the past two presenters that a lot of times there is a history of victimization having, separate and apart from the reason the victim is in front of you on that day. Unfortunately, lightning does strike several times. Just because she was a victim before, it doesn't come in to say that she likes to report victimization. But it also shows, like I said, it cuts both ways. It shows that the person who is victimizing her now may have sensed the vulnerability. Similarly with drug or alcohol abuse, yes, it cuts against credibility because she's had this history of drug or alcohol abuse, but at the same time, there may be a good reason why, all the trauma that may have led to these behaviors. But the idea being, you can only address it if you know about it, and so you have to learn about it. That's when we take the good with the bad, because again, it cuts both ways. And when you think about it, when you're developing credibility, when you're talking to your client, it's going to take several interviews to get the full account. But the idea is that you don't want to have multiple statements, not because obviously it's not good for a victim in her own well-being to have to recount it over and over again. But from being in a courtroom that a victim can be impeached even with the slightest inconsistencies. And so you want to do what you can to limit the number of statements that the victim makes. But understanding that in the civil context, she's likely going to have to be deposed, and how to prepare her. And it's the same idea, going slowly with it, getting her ready for it, getting her to tell you the good with the bad. And then the upshot is that very often opposing counsel will be more uncomfortable saying words like penis and vagina than she will be or you will be. So you'll be better prepared that way. And then I'm rushing through these last slides, but on the next slide, I just want to ask you to keep in mind, right? And this is, again, toward that right side of the continuum that Adriana was talking about. If a victim comes to you and it is in the throes of this just happening, because very often, as I said, these are delayed reports, then think about things like medical issues and injuries. If the sexual assault occurred in the last 72 hours, encourage her to get a forensic sexual assault exam. Not because she necessarily wants to prosecute, not necessarily because she wants to go to the police, but that way she still has that option. And also, just so that she gets the medical treatment that she may need as a result of being assaulted within the past 72 hours. And then again, I don't want to reiterate everything that Jana did, but again, does the perpetrator have continued access? Is there a safety plan? And do you actually want to alert the local authorities? And as I talked about language being important before, in terms of using the word consent and submit, you obviously want to make sure that you're talking to the victim in a language that he or she understands, and enlist either an interpreter or a colleague who speaks the same language as the victim does. And the next slide, the prosecutor may have to ask you to consider available federal and state criminal statutes, right? So if someone comes in there and it gives you an account where they articulate something that may violate a state criminal statute, you just want to be generally aware of what statutes are available in your state and that criminal penalties are possible. And obviously that is a big undertaking for a victim to report it, but hopefully you can work with the prosecutor and understand what the potential remedies are for that, and that could be part of a safety plan. Similarly, I'd be remiss if I didn't point out that there are federal criminal statutes, and just in terms of what I work with, the law enforcement sexual misconduct statute. And I just wanted to point that out because it covers all sorts of law enforcement misconduct, from probation officers to corrections officers to road patrol officers to prosecutors and public defenders who use their authority to commit sexual misconduct. And that may come up in the course of meeting with your client, who may articulate either ongoing sexual misconduct they have with someone like this or in the past. Similarly, in the employment context and in the housing context, the Department of Justice has, we have the criminal portion of the Fair Housing Act. So if you find out that somebody is being raped, for example, by their landlord, we have a criminal remedy. But on the next slide, you'll see that DOJ also has civil remedies. And I point that out as a DOJ employee. I'd be remiss if I didn't. So if you learn of a pattern or practice of harassment in either housing or employment, I encourage you to just look into the available options on DOJ's website. And I'm happy I can talk, for another hour about prosecuting law enforcement sexual misconduct. Obviously, I'll save that for another day. But I do encourage you to just keep those remedies in mind as you're talking to your victims. And I also, on the last slide, encourage you to contact either myself or Melissa. I feel like I spoke very, very quickly. I hope most of you understood what I was saying. And I do encourage you, if you have any questions about any of this, I ran through really quickly. And it is pretty, it's a nuanced undertaking to interview victims of sexual misconduct. So I certainly encourage you to contact us. Thank you.
Thank you, Sarah and Melissa. And this is Jennifer again. I'll let everybody know that we are going to reserve some time after Leslie's presentation for questions. Folks can submit questions to us through the online chat, and we will see them and can bring them up at the end of the presentation. And I know that all of our presenters are open to fielding questions from you all, even after today's webinar also. So with that, I will turn it over to Leslie Orloff.
Hi, I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law. If you have a case involving a foreign-born victim, please do call us. We offer technical assistance, and that information is at the end of the presentation. I just want to start by saying, picking up on some of the things that the other presenters said, is that sometimes immigrant victims and I train law enforcement a lot, so I go back and forth between victims and survivors, so please excuse. But immigrant survivors may be targeted because the perpetrator believes they're a perfect target, because they believe that the victim will be so afraid of immigration enforcement that she won't report, or that her limited English proficiency will interfere with her able to access the court system and get help. So it's really important when you're working with immigrant survivors so that you're creating an accurate record and you understand what really happened, to use a qualified interpreter. The courts will use qualified interpreters, prosecutors will use qualified interpreters, and police officers should too. Otherwise, whatever story about abuse the victim relates will change even though she says exactly the same words because the interpretation was not accurate. So next slide, please. Where I'm going to start is to give you, I'm going to start by talking a very little bit about the importance of screening the survivors you work with for eligibility for immigration relief. This is we call it the SHIELD, but it's a document that was created by the Blue Campaign at the Department of Homeland Security. It is live in that if you click on one of the black circles or one of the boxes, it will take you to the Department of Homeland Security website with information about that program. The sexual assault survivors you work with are primarily going to be eligible when you're talking about workplace sexual assault for T visas, U visas, or continued presence. Those are the predominant forms of relief that they'll be eligible for. However, some victims may also have been victims of domestic violence at home. And what's interesting is unless you have a trafficking case, screening for VAWA self-petitioning eligibility, that would be somebody who was abused by their U.S. citizen or lawful permanent resident spouse or parent, generally. They're, in elder abuse cases, it could be an over 21-year-old citizen child. Those cases move more quickly and get more benefits than U visas. So it's always a good idea to screen for both. They're also easier to do. So next slide, please. So next slide, please. Okay, so VAWA self-petitioning, as I said, these are people who are battered or subject to extreme cruelty. So it includes some forms of emotional abuse, not just sexual abuse or physical abuse. And the perpetrator would have had to be a U.S. citizen or lawful permanent resident, limited to certain family members. And there's no quantity of abuse required for these cases. So if there's been any victimization by battery or extreme cruelty, somebody might qualify as a VAWA self-petitioner. Next slide, please. So the primary form of relief that you're going to see in the cases that you're working with immigrant survivors of sexual assault will be what's called the U visa. And that's a victim of a qualifying criminal activity. I'll show you that list in a minute. They have to have been, are being, or likely to be helpful in the detection or investigation or prosecution or conviction or sentencing of a criminal activity. And I say or because it really does mean or. Somebody who comes forward and tries to call 911, makes a police report, has an initial interview with a prosecutor, could qualifies for a U visa, and they don't have to, they are supposed to provide ongoing cooperation, but if they can show that their cooperation, let's say that the employer threatened them if they cooperated, or they're afraid of deportation, or he said he'll have her turned into immigration, and she believed him, and she stopped cooperating, if she can show to the Department of Homeland Security that her non-cooperation was not unreasonable, all the double negatives, I'm sorry for that, but that's the way it is in the immigration law. If it was reasonable that she didn't cooperate because of the threats or the fear, then she could still get a U visa, despite the fact that she may have changed her mind in terms of the cooperation she offered. And I'm going to go to the point that was made by a speaker earlier that I think is really important. This is where some victims, if you can convince them to do a SART exam, and maybe that's all they'll do at the time, that's enough for U visa certification. And what we've seen is that for U visa victims over time, and these cases take a long time, the victims actually do cooperate in a much greater way than I think we originally envisioned they would. They gain confidence as they begin to trust the system, and they're willing to come forward. So they have to show substantial physical or mental abuse as a result of the victimization. The crime has to have occurred in the United States, and they have to possess information about the crime. Next slide, please. The criminal activities include these, which is a very broad list. It includes, so what's important here for those of you working on sexual violence cases in the workplace is it does not include sexual harassment. It includes sexual assault, sexual exploitation, attempted sexual assault, threatened sexual assault, anything that would be a crime, but you really will have to dig to find, to reach the sexual assault or attempted sexual assault for it to be a U visa case. Sexual harassment in and of itself is not sufficient unless it included sexual assault or attempted sexual assault or threatened sexual assault or solicitation, dignity sexual assault, et cetera, et cetera. Human trafficking is also on this list, and what we find in workplace violence cases is there's often a lot of other things going on. You might have abusive threatened sexual assault and abduction. They might, or kidnapping. They might lock people into the location that they're working at and not let them leave. You might have extortion of wages or other things. So it's important to check off everything and identify in the U visa case anything that applies, because the victims will ultimately need to match up what they get on the certification and the boxes that are checked here with what caused them substantial harm. And in the sexual assault context, that is fairly easy to do. Next slide, please. Another form of immigration relief that's available is the T visa for victims of human trafficking. These are victims of a severe form of human trafficking in persons, which involves sex and labor trafficking involving either somebody who's under the age of 18 or an adult where there's been force, fraud, or coercion involved in either coercing the labor or the sex trafficking. Adriana spoke about this in the beginning, so I'm not going to spend a lot more time on it, but it's important to understand that this is one of the forms of relief. What's interesting here is the VAWA self-petitioning. The trafficking victims get the most public benefits, access and assistance and help. U visas get the least. VAWA self-petitions get next to the trafficking victims, the second most. One of the things that will be on a web page that we're going to post is you'll be able to look up in your state, based on the immigration relief the victim is pursuing, what forms of public assistance are available to her, by state, by program, by immigration status. Next slide, please. And it's really important to screen victims as early as possible for immigration relief and to get those cases filed as soon as possible. Because the cases that get filed for VAWA, T, or U visa immigration relief get put in a red flag system that notifies immigration enforcement officials that this is a victim and that they should be wary that the person who might be calling to try to turn in this victim is her employer or her perpetrator. And there's a high percent of perpetrators that do, particularly if there's a criminal investigation going on, or the potential for one, or a civil case potentially being brought. As soon as they're served, you should be prepared that they may call and try to turn her in. And the best way to be prepared is to file her case as soon as possible. Next slide, please. And that's really what this slide talks about, and you can look at it in more detail, but it's really important to file the case as soon as possible and to give, when you start working with a client that is a U visa or T visa or VAWA self-petition eligible, you want to give them a letter from your office that they can carry with them saying that they're in the process of filing a U visa, because if they're in the process and they show an immigration enforcement official that they're in the process of filing, that immigration, they trigger what's called VAWA confidentiality protections, which are the only statutory protections in anywhere in federal law against immigration, against removal of anybody, but they're only for crime victims. Next slide, please. And it's important also to understand that there's, that when you're filing an immigration case, one of the reasons it's really good as a lawyer doing the sexual assault case or the sexual harassment case to think very strongly about your firm also helping the victim with the immigration case, because the better prepared their immigration cases are, the more likely they'll be approved, and they can avoid the potential dangers of having an immigration case denied, which could eventually, not now, but could eventually lead to the victim's removal. It could trigger her being turned in for immigration removal if her immigration case is denied. That policy has been put off as to these cases as of now, but we don't know for how long. Next slide, please. So, and the other thing to mention that's really important is that once the victim files a U visa or a VAWA or a T visa case, the immigration case file is sealed. It is not discoverable in any civil matter other than potentially the certification. And in the civil court, in the EEOC case that went to the Fifth Circuit, those were anonymized, so there were a number of victims, and they released the certs, but without the names of the people. And in a criminal case, so far the case law nationally is that the only thing discoverable is the certification, because that is if it was done by a prosecutor or police officer. Next slide, please. So now I'm going to turn, before I get to I'm going to finish my discussion about some of the trauma-informed techniques for this population, but before I want to say that it's also important to screen victims for criminal histories, because victims who have criminal histories themselves can still benefit from VAWA-T and U visa immigration relief, but it's much more complicated to make VAWA confidentiality laws work for these victims if their perpetrator employer tried to turn them in. It can happen. We do a lot of technical assistance on this, but it's just more complex. Next slide. So now I'm going to talk about an approach that we developed for working with immigrant survivors. So different from your the civil cases and the criminal cases that involve sexual assault that have been discussed by other folks on the call, when a victim is applying for immigration relief, she needs to tell her story, and it must be in writing. And so what we did was we worked with researchers to develop a trauma-informed approach to the story writing that is built on the social science research and the expertise of psychologists that work with trauma survivors, and developed a technique of approaching these interviews that help women heal from the trauma at the same time you're collecting the evidence you need for the immigration case. And this strategy may help in criminal cases and civil cases as well. Next slide, please. So the way this works is that it's a series of interviews, and each step can take multiple interviews because of the trauma of having to retell the story that the victim goes through. But in the first instance, the first step is to invite her to write her story. If she can write in any language, you want to encourage her with you there, not go home and write it herself, but with you present and assisting her in writing, telling you and writing her story. And that story is unedited, uninterrupted. Those of us that are lawyers always like to interrupt and ask the questions. You do not do that here. You actually make a list of your follow-up questions you want to ask and let it come out however it comes out, however number of sessions you need. You may want, if there's a victim advocate or a therapist that she may be working with, you might want to have them available after the sessions you have, so that if it triggers trauma for her, she can go talk to someone who can assist with her with that. The second stage is a follow-up interview in which we have a structured interview questionnaire that we call for immigration cases that walks you through, and use the question, it basically has embedded in it the questions that researchers ask and have tested that bring out or help clients talk about the trauma they've suffered, including sexual assault. And so this is the time where you'll walk through the structured questionnaire and you'll ask your follow-up questions that you had from the first interview. And again, this can take several sessions. The third step is then you will edit both stories together into a written affidavit that will need to be if she's limited English proficient, translated back into her language. And the fourth step is to have her read the story back to you. And that process of reading and writing and telling helps, what we know from psychologists is it helps victims heal. Next slide, please. And not only does it help victims heal, we believe from using it both in family law cases and in immigration cases that it helps strengthen the legal case, because it gets more information out about more history of trauma than you might be able to do otherwise. And it's important to be transparent and explain this process to your client. Next story, please. Next story, next slide. And that it's a unique opportunity to help people heal. The affidavit in the victim's case, in the immigration case, is less of an affidavit than it is the story, because in the immigration case, this is the way she communicates with the adjudicator. It is her story they're hearing, and they don't want to hear legalese. And it works pretty effectively. Next slide. I explained a lot of these in more detail, and this just kind of reminds you. So this is a kind of pointers on ways to set up the situation when you're working through the first step of her telling her story. You want to create time to listen and talk. Other people use the techniques throughout this webinar that's been discussed. Next slide, please. And then in step 2, you're going to use this SIQI. We're going to have a web page. We have this available in English, Spanish, Russian, and Chinese. We're in the process of getting Korean done, but those are the languages we have so far. So if you're working with those clients, that you can use the tool with them. Next slide. So when you and then here you're going to edit down. This is some pointers on editing the affidavit together, and be ready to kind of address some of the difficulties and go back, and as you edit them together, you'll find inconsistencies and things that you'll want to work with the client through at this stage of the process. Next slide, please. And the goal is that you'll end up with a coherent narrative, a whole story about the abuse that occurred, but also about how that abuse impacted the victim. And that information is going to be incredibly important for the immigration case, because it will help show the substantial harm that occurred to her. And I suspect that harm and how it harmed her will also be important for the criminal cases and the civil cases you're working on. Next slide, please. So this approach can be used for all types of cases, as you can see here. It's designed for VAWA T and U visa case. We have a tool to adapt it to family court cases, and I think we talked with the Time's Up folks about potentially looking at creating a tool to help with sexual harassment cases as well. Next slide. So we have a web library where you can get, if you're doing a case regarding an immigrant victim, there are chapters that explain each of these remedies in detail. There are evidence checklists that are available to help you, and we can get you the information you need. You can do these cases. You do not necessarily need an immigration lawyer. We can help screen the cases. For victims where they had, let's say, a complex criminal history, you might need to find an expert on these kinds of immigration lawyer cases to do them for you. But in most cases, you'll be able to do them yourself with our support, and we work with pro bono lawyers and victim advocates and attorneys across the country who are non-immigration lawyers, helping them do these cases. Next slide, please. And I think I got 22 seconds to go or something. Anyway, these are our materials, how to reach us. We're going to have a web link at this Go link. I'm going to circulate afterwards. We're having trouble with our Go links today, so I'm going to circulate another link to the materials. But it has materials that on our trauma-informed approach, on the immigration relief available. And we also have a YouTube video that we did with Dr. Marianne Dutton that helps demonstrate to you, a service provider that is not an expert, let's say, in trauma or psychology, how to work with a victim who goes into crisis in the middle of your interviews. And Marianne essentially role plays this as the service provider. And it's on our YouTube channel. We'll include a link to that as well. Back to you, Jennifer.
Thank you so much, Leslie, for that presentation, and to all of our fantastic presenters. We have gotten a couple of questions on the chat about logistics, so I'll just address some of those, and then we can turn to some substantive questions for the last few minutes of the webinar. So folks have asked whether we can post Farah and Melissa's contact information again. So we're going to put their slides up, put that slide up so you can see their contact information, since they have graciously volunteered to field questions from you all in the future. We're also going to be posting a recording of the webinar online and materials that our presenters have graciously put together to share with all of you after this webinar. So keep a lookout for that. Probably what we will do is send a follow-up email in the next week or so with links to those materials and to a recording of the webinar. What I'm going to do is read a few of the questions that had come in on the webinar last week and today, and let our panelists address those questions. So the first one that I thought I would ask everyone is this one. Regarding mental health, how can we help our clients get help? In my last case, I saw that she needed help on her mental health, but I wasn't able to convince her to get help. She has an Asian background. There was a cultural resistance. So generally speaking, to any of our presenters, maybe we'll start with Melissa, since she had said she might have something to say about this, have ideas about how to help our clients get help, especially with mental health services.
Sure. I think that there are a couple of avenues where you could locate help. I think the initial thing to do is find out the readiness of the person you're talking to in terms of whether or not they would even want for that, because that may be something that you're seeing that they think, that you're seeing a need in that they may not see it yet. And perhaps I didn't understand the question completely, but I think part of it is having a conversation with the person you're with and saying something along the lines of, there are resources available. If that is something that you are interested in, I am more than happy to put you in contact with the many resources nationwide that we have for X, Y, and Z. And then some of the ways in which you as a professional would seek out those resources in the event that your client expressed interest would be to take a look at perhaps victim advocates at the local, the county, the state government, even the federal government, someone like myself, just in terms of those folks having a really long list of resources that they use when they refer victims and survivors of any type of crime, really. There are also, as you all know, NGOs across the country that have very specific missions, and so it's as easy as a Google search sometimes to take a look at maybe in their particular area if they have a very specific need, looking at some of the larger NGOs in the area and sort of maybe even calling on their behalf to figure out and give them information, meaning your client, that they may be able to use. But I think identifying their readiness is the absolute most important thing.
And this is Leslie. On the link that we'll send you a list of a directory of programs that have experience working with immigrant survivors. Many of those programs have language accessibility as part of their programs. Some immigrant women might be more ready to start with a victim advocate, and then the victim advocate could potentially encourage them or assess their readiness to seek a therapist. Now, the other part is, how do you pay for it? And again, the state by state. So first of all, public health clinics, community and public health clinics have some therapists that might be available through those that for free. So that might be possible. And then there might be assessing what a victim is eligible for from a public benefit standpoint might give you other options to get the services paid for.
And this is Adriana. I just want to emphasize those 1-800 numbers we provided can help you connect with a shelter rape crisis center in an area close to your client, and can also provide some of those culturally specific and language specific services that you are requesting.
Great. Thank you all for those answers. Okay, I'm going to pose another question that has come in, which is this one. What are some best strategies for maintaining your client's credibility? For example, where the survivor has forgotten details or has given varying accounts due to trauma. Can you speak to both trying to prevent these issues with your client and trying to address them in a legal proceeding if it happens in testimony? Sarah, do you want to take that one first?
I can weigh in a little bit. So if it's because of trauma and the recall is scattered for all the reasons you heard, that's when you may want to enlist an expert who can explain the effects of trauma on recall and on giving an account, and whether or not a victim can be linear and so forth. If there are inconsistencies leading up to it, for example, the victim told you one thing in our office, said something different in a deposition, then you just have to have a meeting afterward in preparation for trial and say, hey, you said this, on day 1, and you said this on day 10, and can you explain why? In a non-threatening, non-judgmental way, right? If it seems like that's why, even if you think maybe there's improper motive, you still want to give the opportunity. And it was just a mistake, or she remembered it differently, because there are 1,000 reasons why, as we've heard today, why there may be inconsistencies. And then you just front it on direct examination. You say, is there a reason why you said something different earlier? And she'll have the opportunity to explain why and potentially get crossed on it, but you'll take the sting out of it. No person is ever going to say everything consistently, multiple times in a row, even if they haven't been through trauma. So inconsistent statements, I think, are a natural part of life and litigation. I just think you want to address it when it exists rather than ignoring it and hoping it goes away, because it's not going to go away. So when you see the inconsistencies, ask about it. But if it's due to trauma, then I would enlist an expert.
Thanks. Do other folks have answers that they want to give to that question?
Well, I'd like to add, if you're in Texas, or even if you're not in Texas, the University of Texas Institute on Domestic Violence and Sexual Assault trains advocates at shelters and rape crisis centers across the state of Texas to be expert witnesses on sexual violence, domestic violence, the impact of trauma. And so consider them as a resource if you're looking for an expert witness in Texas, or one that could testify by phone remotely, or they may have connections to an expert witness in your state, wherever you practice. But there are usually different programs that are committed to bolstering the efforts of attorneys and providing expert witnesses services.
Thanks, Adriana.
And this is Leslie, can I just add something? And then what also may come up is that if you're working with an immigrant victim, you might need an expert witness to talk about immigration relief and explain it to the jury so they understand that the victim, that is entitled to this relief because she's a crime victim, and there's certain strategies that prosecutors can use to avoid the impact of the immigration issues on the criminal case. And so having an expert on immigration might be helpful and necessary, and we can connect you potentially with people depending on where you are in the region, in the country.
Great. Thank you. So we are just at the end of the time that we had allotted for the webinar. So I am going to bring it to a close. Thank you so much to our fantastic presenters, Sarah, Melissa, Adriana, and Leslie. That was incredibly informative. Thank you again to Neela, to the National Employment Lawyers Association, for co-hosting this webinar for us. Thank you to all of the fantastic attorneys who volunteer their time with the Legal Network for Gender Equity. Keep your eyes out for an email to come from us with a link to the recording of this webinar and materials that are going to be posted from our presenters. And stay tuned for more webinars to come from us as well. Thank you all.
Thank you.